A big claim is circulating right now. A former U.S. consular officer says the H-1B system is being manipulated, and that there is widespread fraud involving shell companies and fake job listings, with particular attention on listings tied to Texas. That kind of headline can make people panic, because H-1B is not just a visa. For many families, it is the bridge to staying employed, maintaining status, and eventually getting a green card. So in this video, we are going to slow down and separate three things: what these fraud allegations usually mean in practice, who actually gets hit when enforcement ramps up, and the specific steps you can take right now to reduce risk if you are a worker, a student hoping to transition, or an employer sponsoring someone. And yes, we are also going to talk about the big question people argue about: reform versus scrapping the program. But we are going to do it in a way that is grounded in process, not rage. First, let us be careful with words. When you hear whistleblower, exposed, rigged, or massive fraud, those are framing words. They might point to real problems. They might also be exaggerated for clicks. What we can say without overclaiming is this: H-1B is a high-demand program with strong incentives to game the system, and U.S. agencies have long treated certain patterns as fraud risk indicators. That means that when stories go viral, you can see knock-on effects: more scrutiny, more requests for evidence, more site visits, and more difficult questions at visa interviews. Here is the part most people miss: enforcement pressure does not land equally. Some workers with real jobs and clean paperwork still get delayed or stressed, while certain business models and certain petition patterns attract the most attention. So let us start by defining what we actually know versus what is still just a claim. The brief you saw mentions a former consular officer alleging widespread fraud, plus journalist and lawmaker concerns about shell companies and fake job postings. Those are allegations and concerns, not a new law, not a new official ban, and not an automatic denial wave. There is no single switch that gets flipped where every H-1B case is suddenly suspected. In the real world, what tends to happen is incremental, targeted scrutiny based on risk factors, random audits for deterrence, and policy conversations that may or may not lead to changes. If new official actions emerge, they usually show up as public agency guidance, operational announcements, or increased use of existing tools like RFEs and site visits. Until you see that, the most productive thing you can do is tighten your compliance and your documentation. Now, quick H-1B in plain English, because it helps you understand where fraud can occur. H-1B is an employer-sponsored work visa. The employer files a petition, generally on Form I-129, to USCIS. In many cases, it is subject to a yearly cap and a lottery. The position must generally be a specialty occupation, meaning it requires specialized knowledge and at least a bachelor degree or equivalent in a related field. The employer also files a labor condition application, or LCA, promising to pay at least the required wage level and to comply with labor rules. After USCIS approval, if you are abroad, you typically do visa stamping at a U.S. consulate to enter in H-1B status. If you are already in the U.S. in another status, you may do a change of status. There are lots of variations, but that is the skeleton. So where can fraud happen? Usually in one of four places. The job is not real. The employer is not real. The wages or working conditions are misrepresented. Or the worksite and supervision reality does not match what was filed. When people talk about shell companies, they often mean an entity that exists on paper but has minimal real business operations, used primarily to file petitions. When people talk about fake job listings, they often mean postings used to create an appearance of recruiting, or to justify roles that do not exist, or to create paperwork support for a petition. And when people talk about rigged systems, they often mean gaming the lottery by filing multiple registrations through related entities, or by creating patterns that increase selection odds. Again, that is the general concept people argue about. Specifics depend on facts and evidence. This is where people get denied. Not because they are talented, not because their degree is good or bad, but because the paper story and the real-world story do not line up. If your petition says you will work at location A under employer A supervision, but in reality you are full-time at a third-party client with unclear supervision, and the paperwork does not clearly explain that, that is when scrutiny spikes. If your wage level does not fit your claimed duties, that is another trigger. If your company cannot show it has enough projects and revenue to pay you, that is a trigger. If there is benching, meaning you are unpaid between assignments, that is a labor compliance problem that can spill into immigration issues. And if the job is simply not real, that is the most serious category. Now let us talk about who is affected versus who is not, because this is what most viewers care about. Group 1. H-1B workers employed directly by established companies, doing work that matches their degree, with consistent pay stubs, a stable worksite arrangement, and clean documentation. You are not immune from delays, but you are generally in the lower risk bucket. Group 2. People at smaller or newer companies that are real, but have messy documentation, rapid changes, or a business model that is harder to explain, like staffing, consulting, or heavy third-party placement. You may be completely legitimate, but you are more likely to face questions because your fact pattern is harder to verify. Group 3. People involved with companies that cannot demonstrate real operations, cannot demonstrate real work, or are using arrangements that look like paper jobs. This group faces the highest risk, including denials, revocations, and possible long-term consequences. Group 4. Students on F1 or STEM OPT watching this and thinking, should I even try H-1B? You are affected indirectly because rumor cycles and enforcement cycles can influence how picky employers become, how cautious lawyers become, and how USCIS reviews certain types of petitions. But your best move is not panic. Your best move is choosing a real employer and building a real, documentable work history. Here is a micro hook that matters if you travel. Even if USCIS approves an H-1B petition, the consular officer at a visa interview can still ask hard questions about the employer and the job. They are looking for credibility. So if you are in a higher scrutiny bucket, travel can be where stress shows up, because stamping adds another layer of review. That does not mean do not travel. It means plan travel carefully and carry the right supporting documents. Now let us do a quick myth versus reality, because the comment section gets chaotic on this topic. Myth: H-1B fraud means most H-1B workers are fraudsters. Reality: most workers are just trying to do their jobs and keep status. Enforcement is usually aimed at patterns, not entire nationalities or entire occupations. Myth: if fraud exists, every H-1B case will be denied. Reality: USCIS adjudications are case by case. Increased fraud talk can increase scrutiny, but it does not automatically rewrite eligibility rules overnight. Myth: if your employer is a staffing or consulting company, you are automatically illegal. Reality: staffing models can be legal, but they require strong documentation about the actual job, the worksite, supervision, and wages. Weak paperwork is what kills cases. Next, why is this happening now, at least in the broader sense? There are a few drivers that repeatedly show up when H-1B fraud debates flare. One is demand. The cap and lottery create scarcity. Scarcity creates incentive to game the system. Another is the rise of remote work and multi-site work, which can blur where the job is performed and who supervises the worker. Another is public pressure. Lawmakers and journalists pay attention when they see patterns like many similar job postings, clusters of registrations, or companies that seem to exist primarily to file for visas. And then there is a basic bureaucratic factor. Agencies respond to risk by using the tools they already have. That means more RFEs asking for proof of specialty occupation, proof of employer-employee relationship, and proof the job exists and is available. It can mean more FDNS site visits, where government officers verify the company location and the worker role. It can mean closer scrutiny of wage levels and LCAs. None of that requires a brand new law. It is just a shift in how hard existing rules are enforced. Here is the part that changes everything for many viewers. Even if you are doing real work, if your story looks like a fraud pattern from the outside, you may get pulled into delays. The best defense is documentation that makes your case simple to understand. So let us talk consequences in the real world. First, processing delays. If you receive an RFE, you can lose months. Second, travel and stamping risk. If you leave the US and need a visa stamp, you may face additional questions, and in some cases, administrative processing that delays your return. Third, job changes and transfers. If you change employers, you want the new petition to be clean, because a messy transfer can create a chain of issues. Fourth, extensions. When you extend, USCIS rechecks the story. Were you actually doing the job at the location for the wages stated? Pay stubs, W-2s, client letters, and project documents start to matter. Fifth, green card processes. Some viewers are in PERM or I-140 stages. A shaky H-1B history can create anxiety later, even if each stage has its own standards. It is not automatically disqualifying, but it raises the importance of consistent records. Let me give you an example scenario, clearly hypothetical, but realistic. Example scenario number 1. Priya works for a small consulting firm. The job is real, she is paid properly, and she has a legit degree match. But the firm places her at a client site, and over the years she moves between 2 client locations and spends some months working remote. Nobody updates the paperwork, and her file still shows the original location and generic duties. Then her extension gets an RFE asking for proof of specialty occupation, proof of worksite, and proof of employer control. Priya panics because she thinks she did something wrong. What actually happened is the file is weak. The fix is not a fake letter. The fix is accurate documentation, updated worksite information where required, clear project descriptions, evidence of supervision, and consistent pay records. Example scenario number 2. Alex gets recruited by a company that promises an easy H-1B, but the job description is vague, the wage seems low for the claimed role, and the company cannot clearly explain what projects they have. Alex is told not to worry, they will handle it. That is the high-risk zone. Even if Alex personally did not intend fraud, being attached to a paper job can create serious consequences. The safest move is to avoid that situation before it starts. So what should you do now? I am going to give you a practical do this and avoid this checklist. This is general information, not legal advice, and you should tailor it to your situation with official sources or a qualified attorney. But these steps are what reduce risk in real life. Do this if you are an H-1B worker. Keep a clean folder of basics, your most recent approval notice, your job offer letter, your job description, and a current employment verification letter. Keep pay evidence, recent pay stubs and W-2s, because they show you are being paid consistently. Keep work evidence, a simple record of projects, manager names, and where the work is performed. If you work at a client site, keep whatever documentation you are allowed to keep that shows the assignment is real, like a project summary or a client letter if appropriate. If your worksite changes materially, do not ignore it. Ask your employer or counsel whether an amendment is required. Avoid this. Do not let anyone file something with duties you do not actually do, or a location you do not actually work, just because it seems easier. Do not accept benching without pay. Do not assume remote work means location does not matter. Do this if you are changing employers. Choose employers that can clearly explain what you will do, who supervises you, and how they can pay you. Ask what documents they will provide if USCIS questions the role. Avoid this. Do not treat a transfer like a paperwork-only move. Transfers are often a moment of scrutiny, and weak filings can create delays that affect your ability to work and travel. Do this if you are an employer. Build a compliance binder for each H-1B worker. Keep the LCA public access file requirements in mind. Ensure wage levels and job duties match. If you use third-party worksites, document the employer-employee relationship clearly, including supervision and control. Avoid this. Do not overpromise on job titles or duties to make the case sound more specialized than it is. And do not use related entities to multiply lottery chances. Even if someone says everyone does it, patterns can be detected and consequences can be severe. Now, another myth versus reality, because I see this all the time. Myth: if USCIS sends an RFE, you are basically denied. Reality: many RFEs are winnable if the job is real and the documentation is strong. The bigger issue is time. RFEs cost time, money, and stress. Myth: consular officers only care about your degree. Reality: at stamping, they can care a lot about the employer credibility and the job reality, especially if the petition pattern looks unusual. Now, what about the question in the brief? Should H-1B be reformed or scrapped? Here is the grounded way to think about it. Scrapping would be a major legislative and economic shift and is not something that happens quietly. Reform, on the other hand, is an ongoing conversation that can take many shapes. Changing how the lottery works, changing fees, increasing audits, adjusting wage-based selection, tightening rules for third-party placement, or increasing penalties for bad actors. Whether any particular reform happens depends on politics, agencies, and lawsuits. So the practical takeaway is not to guess. It is to watch for official guidance and to run your case like it will be audited, even if it never is. Here is what to watch next, safely, without getting dragged by rumors. Watch USCIS announcements and updates related to H-1B registration, petition filings, and fraud warnings. Watch Department of State communications if you are planning stamping abroad. Watch for patterns. Are more people in certain job models reporting RFEs or administrative processing? That is not proof of a new policy, but it is a signal of enforcement focus. And watch for credible reporting from multiple independent sources, not just one viral clip. If you are in a higher risk bucket, here is a simple "if you are in X group, do Y" segment. If you are at a consulting or staffing firm with third-party placement, do this week. Ask for a clear letter describing your duties, the worksite, the supervisor chain, and how your employer maintains control. Keep a current client assignment document if you can. If you are at a small startup, do this. Make sure the company has basic proof of operations and ability to pay, like funding or revenue evidence, and a clear organizational chart. If you are traveling for stamping, do this. Carry a full packet that makes it easy to understand your role, and consider asking your employer what they typically provide for interviews. Avoid any documents that are exaggerated or inconsistent. Consistency is your friend. One more thing people forget. Do not rely on social media for the final word. The safest verification sources are official agency websites and your case status portals. If something is truly official, it will be reproducible. It will appear in guidance, forms, FAQs, or public statements that can be checked. Now I want to zoom out to the real point behind these stories. Fraud narratives are not just about bad actors. They also increase the burden on legitimate people because scrutiny goes up and timelines get slower. That is why your goal is to be boring and documentable. A boring case is a strong case. Your duties match your degree. Your wage matches your duties. Your worksite story matches reality. Your pay stubs match the LCA. Your company can explain the role in 2 minutes. That is the standard you are aiming for. Let us recap in 5 calm bullets. 1. A whistleblower-style claim and broader reporting about H-1B fraud can signal increased attention, but it is not, by itself, a new rule. 2. Fraud risk is usually tied to specific patterns like shell entities, fake jobs, unclear third-party placement, mismatched wage and duties, and inconsistent worksite records. 3. Most legitimate workers are not the target, but they can still be affected by delays and extra scrutiny. 4. The best protection is documentation and compliance. Keep pay records, clear duty descriptions, and accurate worksite information, and avoid arrangements that do not match reality. 5. Watch official updates, not rumors, and plan travel and job changes with extra care when headlines spike. If you found this helpful, subscribe and turn on notifications because I will keep tracking credible updates and translate them into plain English without panic. And I want to hear from you. What part of the H-1B process feels most confusing right now? The lottery, the job description, third-party placement, or stamping? Drop your situation in a general way in the comments, and I will make a follow-up that answers the most common questions.